All right, welcome aspiring barristers. In this explainer, we are going to unlock one of the most powerful procedural tools you will absolutely need for the bar exams, and definitely for your career beyond. We're talking about Section 23 of the Federal Court of Australia Act. Now, I want you to stop thinking of it as just a number. It's not. It's a master key to a whole range of judicial orders.
So let's kick things off with a classic barrister's dilemma. Picture this. You're in chambers, it's late, the coffee's gone cold. Your client needs an urgent order right now to stop something disastrous from happening. You've been tearing through the federal court rules, but there's nothing, no rule that perfectly fits your situation. What's your move? This exact scenario is why you need a rock-solid grasp of the court's inherent power.
And the answer, of course, is Section 23. But here's the thing. To use it properly, you have got to understand the critical difference between the court's jurisdiction and its power. They are not the same thing, and mixing them up is a rookie mistake you don't want to make.
Okay, so let's break this down. Jurisdiction is the court's basic authority to even hear a case in the first place, and it gets that from other statutes. Section 23 of the Federal Court of Australia Act, it doesn't grant jurisdiction. What it does is confer power. It's the method, the how. The court exercises the authority it already has.
And this quote right here, this shows you just how incredibly wide that power is. The High Court's words in Jackson v. Sterling, this is pure gold for your exam notes. They're basically confirming that Section 23 is this huge reservoir of authority, letting the court make pretty much any order it thinks appropriate to get justice done.
All right, let's open up the toolkit. First instrument we're pulling out is the interlocutory injunction. Its job is pretty simple, really. It's all about preserving the status quo. Keeping things as they are until the court can make a final call. And its authority? It flows straight from the broad powers of Section 23.
At its heart, the whole test for getting an interlocutory injunction really stands on two main pillars. First, you've got to show that there's a serious question to be tried. And second, you have to persuade the judge that the balance of convenience is in your favor. That just means the potential harm of not granting the injunction is way worse than the harm of granting it.
Now, for your exams, you absolutely have to have the three-part test from Australian Broadcasting Corporation v. O'Neill down cold. It refines those two pillars into three clear steps you've got to jump through. 1. Establish that serious question. 2. Show your client is going to suffer an injury that just throwing money at later won't fix. And 3. Prove that the balance of convenience really does tip in your client's favor.
And here's a really crucial distinction. For a prohibitory injunction, that's one that stops someone from doing something, you use that standard serious question test. But if you want a mandatory injunction, one that forces someone to do something, well, the court needs what it calls a high degree of assurance that the order is the right call. That is a much, much higher bar to clear.
Okay, let's move on. We're grabbing a more aggressive tool from the kit now. This is for when you're worried your client's going to win the case, but then be left with a judgment that's worth nothing. We're talking about the Mareva order, or as it's more commonly called these days, a freezing order.
A freezing order is basically a powerful preemptive strike. It stops a defendant from getting rid of their assets, moving them offshore, selling them off, hiding them under a mattress, all to make sure that if you get that win, there's actually something there to satisfy the judgment. And yep, this power comes from Section 23 too.
So, how do you get one? You have to meet a very specific test. For the exams, remember the wording from Rule 7.35 of the Federal Court Rules. You need a good arguable case. Notice that language. It's a higher standard than just a basic prima facie case. And you've got to bring solid evidence of a real danger that those assets are about to vanish, which would totally frustrate a future judgment.
And now, for what is probably one of the most draconian, most severe tools available in civil litigation, the Anton Pillar Order, also known as a search order. This is your break glass in case of emergency option. You use this when you have a genuine fear that a defendant is literally about to destroy crucial evidence.
I mean, just think about what this order actually does. It's an ex parte order, which means you go to the judge without the other side even knowing you're there, and it compels a respondent to let you onto their property to search for and physically seize material. It is a massive intrusion, which is exactly why the bar is set so incredibly high.
And here is that high bar. To get an Anton Pillar order, you have to satisfy all 4 of these strict conditions from the original case. And I mean all of them. You don't just need a good case, you need an extremely strong one. The potential damage has to be very serious. You need clear evidence they have the stuff, and a real possibility they're about to destroy it. If you miss even one of these, your application is dead on arrival.
Look, any powerful toolkit needs a good user manual, right? Wielding Section 23 isn't about having limitless power. You have to know the constraints. You have to know the hard limits, especially when the court is going to stop you from using it to get around other laws.
This right here is a massive exam point. If there's another statute, say the Competition and Consumer Act, that lays out a complete and exhaustive list of all the available remedies for a particular issue, you cannot use the general power of Section 23 to just invent a new one. The specific act will always trump the general power.
And this quote from Thomson Australian Holdings is the perfect summary of that principle. Seriously, memorize it. The High Court could not be clearer here. When a specific act creates its own complete world of remedies, you have to play by its rules. Section 23 isn't a get-out-of-jail-free card to go beyond them.
So there you have it. That's the toolkit: the injunction, the freezing order, and the search order. Section 23 is no longer just some number in an act. It's your key to being an effective advocate. Understanding its power, how to apply it, and, just as importantly, its limits, that's absolutely fundamental stuff. So, when the time comes, which tool will you reach for first?